Well, we are here. We are preparing for a matter, anyways, and the guys have switched off the fan so that the documents don't fall off. So I thought I might as well take the benefit of the absence of the fan noise and make a small video talking about how sometimes anticipatory bail can be a double-edged sword. Now, an example would kind of explain what I'm talking about. Recently, a person came to me and told me that one of their maids falsely accused them of certain acts, beating, nothing, no sexual offense, but yes, of beating, of not paying money, not paying salary, and keeping the person forcefully inside the house, stuff like that. Couple of those offenses punishable under the Juvenile Justice Act, couple of them under the regular provisions of the IPC. Now, the person asked me what can be done, and I explained to them that if they go and seek anticipatory bail from the court, right now the police, because of the kind of whatever they told the police, and the police kind of believed their statement. But in these kind of situations, I explained to them that in case third parties get involved, in case some organization belonging to the government gets involved and asks the police, why haven't you gone and apprehended the accused persons despite the offense being a cognizable and a non-bailable offense, then the police will automatically show up at your door and perhaps straight away arrest you, and in all likelihood they will arrest all the males in the household. They might let the females of the household let them get away. And in this kind of a situation, I explained that it would be more prudent to get anticipatory bail. But I also had to explain to this client that in case they apply for anticipatory bail, the police will then have to come to court and tell them and tell the judge that they do want custody and they will want to oppose the anticipatory bail. And until that time, they can sit a little tight and they don't need to go. But just in case, there's always that little ambiguity, that doubt, that apprehension that any day, because of some pressure, the police might show up and might just come and arrest us. And that is why anticipatory bail is always a double-edged sword. In fact, very recently in a case, the police were again not ready to name one of the perpetrators, who my client knows is the perpetrator, as an accused in the matter. Now, after we filed an application for monitoring of the investigation, after the magistrate directed the police to submit their pass orders, monitoring of investigation, pass certain orders against the police, it is then that this perpetrator applied for anticipatory bail. And the moment the person applied for anticipatory bail, granted, the person did get anticipatory bail. But now, where we were earlier not sure whether this person will be charged for the offense that we are alleging, now for sure the police will have to file a charge sheet against this person and proceed against this person, and the trial will go on, and there will be either conviction or acquittal. But in either case, now the person has definitely become an accused person. And this is the problem with anticipatory bail. Just in case you were perhaps a witness or not even a witness, and the police were completely ready to let you off, you, by filing an anticipatory bail under section 438 of the Criminal Procedure Code, have now guaranteed that the police will investigate you as an accused person. There are very, very few situations in which, despite you filing anticipatory bail, the police will ultimately cite you either as a witness or perhaps not an accused at all, and they will just let you off the hook. Happens very, very rarely. Having said that, 99 out of 100 times anticipatory bail in such situations, when you are considering getting anticipatory bail, you should get it. And the reason why for a moment I thought that I didn't even press record. And the reason why is that this is a hypothesis which is there only in 1 out of 100 cases. It does happen, so you have to be mindful that it should not be a situation where there is no allegation against you, your name is not bound to crop up at all. In fact, in a lot of these matrimonial offenses, it is advisable for the husband to get anticipatory bail, but not for the parents to get anticipatory bail immediately, unless there are some other things which are moved by the other party, unless the police in their investigation, something crops up and they say, yes, there is something substantial that comes up against the, the parents of the husband. So, in all likelihood, you will have to get anticipatory bail from the court. If it is dismissed by the Sessions Court, you apply to the High Court. If the High Court dismisses it, you file a special leave to appeal under Article 136 of the Constitution to the Supreme Court of India. Whatever is required, you make it happen, get anticipatory bail. But it is just in those 1 out of 100 situations where perhaps applying for anticipatory bail is not the best idea because of the aforementioned reasons. That's all for today. If you liked this video, please subscribe and press the thumbs up. Thank you.